Right, and we'll get started. Um, Good evening, and thank you for joining us. My name is Mark Burgess, and I'm a librarian with the Civic, Cultural, and Literary Engagement Department at the Chicago Public Library. Tonight's virtual event is part of our Law at the Library series in partnership with the Evanston Public Library and the Chicago Bar Association. We continue to be grateful to the CBA for their continued support for this public information series. The presentation portion of tonight's program will be recorded, as I said, and available for later streaming on the Evanston Public Library YouTube channel. During tonight's program, we'll be monitoring an online chat for questions from the audience for a Q&A following the conversation. Please type your questions by clicking the Q&A button at the bottom of your screens, and we will get to them at the conclusion as time allows. So with that, I am pleased to introduce our speaker for this evening, Mr. Kerry R. Peck. Mr. Peck is the managing partner of the Chicago law firm Peck Ritchie LLC, where he concentrates his practice in trust and estate litigation, estate planning and administration, guardianship, fiduciary litigation, and elder law. His clients have included families, hospitals, banks, the state of Illinois, Cook County, and the city of Chicago. Mr. Peck was a member of the Alzheimer's Association Greater Illinois Chapter Board of Directors for over 5 years. He is past president of the 22,000 Lawyers Chicago Bar Association, is currently a member of the American Bar Association's Commission on Law and Aging. Mr. Peck was recently appointed by the Illinois Supreme Court as chair of the Illinois Supreme Court Commission on Elder Law. He was retained by the City of Chicago Department of Aging to rewrite the State of Illinois Elder Abuse and Neglect Act. Mr. Peck has been instrumental in working on legislation to protect older adults at the federal, state, and local levels. For over 15 consecutive years, he has been selected by his peers as a super lawyer, which is an attorney to whom other attorneys would refer their family, and he was named a member of the Leading Lawyers Network and U.S. News and World Report, together with the best lawyers, named Peck Ritchie a Tier 1 elder law firm in Chicago, a designation reflecting the high level of respect a firm has earned in the community for their abilities, their professionalism, and their integrity. Mr. Peck is the recipient of the 2014 Justice John Paul Stevens Award, the Chicago Bar Association's highest honor. He was also selected by IIT Chicago Kent College of Law as one of their 125 alumni of distinction. Kerry co-wrote the books Alzheimer's in the Law and Don't Let Dementia Steal Everything, published by the American Bar Association, and is a frequent speaker at continuing education seminars for attorneys and healthcare professionals across the country. And he has presented for the Alzheimer's Association at numerous events. So thank you again for attending this program. And with that, I will hand it over to Mr. Peck.
Good evening, ladies and gentlemen. Thank you, Mark, for that kind introduction. Appreciate that. And we look forward to a terrific interactive seminar tonight. As you know, we're going to talk about guardianship and powers of attorney. If you have questions, please put them in the chat. And as Mark indicated, at the end of the presentation, we'll get to as many as time allows. So let's take it away, please, Chelsea. So why is guardianship necessary? And I think perhaps we first should start talking about what is guardianship, but we'll get to it a little further. Guardianship is often necessary because POA, power of attorneys, are abused. People use them for improper purposes or financial exploitation. Someone is unduly influenced to sign a document. We have what we call a breach of fiduciary duty. There are many individuals that hold what we call fiduciary duties, trustees, agents under powers of attorney, executors, bankers, things like that. And of course, guardianship is necessary if someone is a disabled person. Typically, that disability refers to a cognitive disability. They may be physically incapable as well, but the terminology usually refers to a cognitive disability. And as I mentioned, often financial exploitation cases require guardianship. Next slide, please. So guardianship is really kind of a constant battle, so to speak, between autonomy, meaning basically independence, and protection. And all competent adults in our society have the right to make mistakes, to exercise poor judgment, and to make choices that are contrary to their best interest. But the most important part about that bullet point is that individual is competent. So neither disagreement with recommendations of service or medical providers, which usually is where it comes up, nor the refusal to cooperate with efforts to prevent or rectify physical, emotional, or financial abuse in and of itself is justification for a guardianship. Next slide. So in Illinois, the term advance directives means powers of attorney. You'll note when we started, we were talking about guardianship and powers of attorney. Advance directives is the same thing. So when an advance directive is not in place or fails, the primary purpose of guardianship is to establish a legally authorized substitute decision maker for someone who lacks capacity to make or communicate responsible decisions. So guardianship is a court proceeding in which a judge or a jury determines that someone is incapable of making decisions. Again, 90+% cognitively impaired from perhaps Alzheimer's disease, from perhaps a stroke, from perhaps a heart attack that causes them to lose the ability to breathe or to get blood up in their brain. A lot of different maladies cause people to be cognitively impaired. So guardianship is only utilized when necessary to promote the well-being of the disabled person, to protect him or her from neglect, exploitation, or abuse, and to encourage development of his or her maximum self-reliance and independence. Next slide. So if a person is capable of understanding the available options and deciding what he or she wants, guardianship's not appropriate. But again, is that person capable? Do they have the cognitive ability, the mental ability to determine if the recommendations that have been made to them are something they understand and can decide what they want? They can oppose it on religious grounds. They can oppose it because they don't think it's necessary. They can oppose it on a lot of grounds if they have the mental capacity. So even if an individual chooses not, for example, to have a medical treatment that might be in their best interest, if they understand their choice and if, capital IF, they have the capacity to make the decision, then they're able to do it. And we need not go in and get a guardian. But the question here, ladies and gentlemen, is, do they have the capacity? So powers of attorney, again, the terminology is interchangeable with advance directives. Many of you perhaps recall the Doublemint twins. And why do we have the Doublemint twins up there? Because when we create a power, we basically pick what amounts to our clone, okay? But it's called our agent to make decisions. We grant legal authority. This is a legal document granting authority to someone else who you trust to act for you in certain circumstances. Again, potentially what I call your legal clone, a la the Doublemint twins, one picking the other to make decisions for them when they're not able to make their own decisions. The existence of power of attorney documents avoid the necessity for a court determination of mental incapacity or a guardianship. So in Illinois, we have two types of powers of attorney. We have a power of attorney for health care. And as you can see, the words there are descriptive of themselves. This is for medical decisions. We appoint an agent. I appoint Mark our librarian tonight, as my agent to make healthcare decisions on my behalf if I become incapacitated. A healthcare power of attorney gives my agent the general directives that must be followed, but yet it allows some flexibility. Your agent can decide what you would have wanted done in each scenario. That's why you want to pick someone who you know and you trust. A healthcare power of attorney uh, is useful because it allows the doctor or the hospital to release all necessary medical information to whomever you choose as your agent. Now, you recall today when you go into the hospital or you go to the doctor, everybody says, oh, I need you to sign a HIPAA waiver if you want somebody else to get the information. Well, HIPAA is going to tell us what we can release to someone. Under a power of attorney for healthcare, your agent gets all of the medical information, all access to records. Now, there's a fly in the ointment here. The bottom bullet point. A power of attorney for healthcare is revocable regardless of mental status. So even if I'm deemed to be incapable of making my own decisions and I previously signed a power of attorney for healthcare, I still can revoke that power of attorney for healthcare, eliminating my agent's ability to make decisions. If that happens in a crisis scenario, we will be forced to go into court and ask the judge or a jury to decide who will make decisions. That's what a guardian is. Who will make decisions for someone that didn't plan and is incapable of making their own decisions. As I said, powers of attorney come in two forms or two flavors in Illinois. A power of attorney for healthcare and a power of attorney for property. Now, the term property does not mean exclusively real estate. The term property means all of your assets. So it could be real estate, it could be your bank account, it could be your checking account, it could be your stock account, it could be anything you want it to be, provided it's an asset in your name. So a power of attorney for property, again, think back to the Doubleman twins picture. I name, in this instance, Chelsea to be my agent under my power of attorney for property. Should I become incapacitated, that power of attorney agent, Chelsea, can make decisions for me regarding the management of my assets. This avoids the necessity of a court proceeding guardianship. It includes the authority to manage real estate. It includes perhaps the authority to change the title on property. It's especially useful for assets that cannot be owned jointly. Joint assets are generally owned by husband and wife. Husband A, wife B own the assets in joint tenancy, which is short for joint tenancy with right of survivorship. Husband dies, the assets passes to his wife outside of probate. No post-death probate proceeding. Guardianship, you should be very clear, is a lifetime probate proceeding. Most people are familiar with probate only occurring after death. Guardianship is a lifetime proceeding. You can see the list of assets that a power of attorney for property would be helpful in managing: a healthcare savings account, an IRA, retirement plans, perhaps a 401k, or property not put in trust. So a power of attorney for property and a power of attorney for healthcare, they are powerful devices. They are lifetime devices. They die when you die, but you name someone during your lifetime while you're competent to make decisions for you when you're not competent, to avoid that court lifetime proceeding called guardianship. Next slide. So what if you don't plan? Well, if you don't do powers of attorney, ladies and gentlemen, we're going to guardianship court should you have a stroke that impedes or dramatically impacts on your ability to make your own decisions. And a guardian is appointed by the court to serve as a representative of the person of an adult under legal disability. So again, those legal disabilities come in a lot of different forms and a lot of different shapes. Could be Alzheimer's disease again, could be a stroke, could be any illness that impacts your cognitive, your mental ability to make decisions. The guardian could be a family member. The guardian could be an agency that competently provides services. The guardian could be, there are some government agencies, the Office of the Public Guardian in Cook County, the Office of the State Guardian is a state agency, and a court-appointed guardian may make decisions consistent with the procedures and requirements of the Probate Act without judicial involvement. But don't get confused. The court will be intimately involved and oversee everything. The court will appoint that guardian, manage the money that guardian is authorized to use, manage healthcare decisions, and the like. Last point there. A diagnosis of Alzheimer's disease alone is not an indication of incompetence. So Alzheimer's disease, as you know, is a progressive disease, typically in a very downward trend for an individual's capacity. But when an individual is diagnosed with Alzheimer's disease, in most instances, they still retain the capacity to make decisions. It depends on how far along the disease has progressed, and it depends on the diagnosis. For example, a diagnosis of frontal temporal lobe dementia is more than likely going to mean that the individual is not mentally competent. A diagnosis of Alzheimer's disease, early diagnosis, stage 1, is not likely to lead to a determination of incompetency. But as the disease progresses, as time progresses, and again, as that cognitive ability goes down, 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 then it may need, that individual may need a court-appointed guardian if they don't plan. When someone is competent and executes a power of attorney for property and a power of attorney for healthcare, they can avoid that lifetime court proceeding. Next slide, please. So guardianship is really the default estate plan for disability purposes in Illinois. If we have a disability affecting cognition, question is, can that person make decisions for themselves? If there is no effective or ineffective planning for disability, the question is, does that individual have a proper plan in place? Meaning, again, I sound like a broken record. Do they have a power of attorney for healthcare? Do they have a power of attorney for property? Don't forget, we haven't talked about wills. Why? Because a will is a post-death effective document. Wills have nothing to do with your lifetime planning. A will is not used to determine who's going to manage your medical decision-making when you're not competent to do so. A will is not going to determine who's going to manage your assets when you're not competent. Agents under powers of attorney are going to be those people under validly executed documents while competent. So is the plan appropriate or valid? Well, if you don't have a plan, obviously it isn't valid. If the documents were not done properly, were not witnessed properly, were not notarized, are not statutory. Bear in mind, in Illinois, we have statutory, which means literally it's in the law, word for word, statutory, what those documents must say and what choices you must make. For example, is a document effective immediately? Is a document effective only if a doctor determines that you're not competent? And are your agents willing to act? When I name Mark and Mark says, you know what, I don't want this job anymore. Maybe I've named a successor agent, Chelsea. She can act. but it's important your agents are willing to act. Note at the bottom, guardianship can be an effective tool to combat financial exploitation. Next slide, please. So, as we assess the need for guardianship, we do a determination as to whether this person is disabled, to what extent a disability has any practical impact upon the decision-making capacity, particularly the need for guardianship, the assessment of the least restrictive options for care and treatment, and those should be made by qualified medical and other specialists. Very important. A critical component for a judge or a jury to determine if someone needs a guardian is a medical report. The Illinois law and all guardianship law, coast to coast, requires that the guardianship determination be based upon a medical finding that an individual lacks the mental capacity to make their own decisions. So what's the diagnosis? What's the future hold? Are they capable of making perhaps medical and not financial? Are they capable of making little decisions? Are they capable of making decisions that will impact their life and death decisions in healthcare and the like? We rely on the medical community. We rely on a doctor licensed in Illinois who has to provide a license number. That doctor will be required to determine and to opine, to make a statement in print. Mark, Carrie, Chelsea are capable, they're incapable. They need a guardian. How capable? They're totally capable. They're partially capable. How can they make decisions and to what extent? In writing by the doctor. The judge will rely on it and the law requires it. Next slide. So this is again all statutory, straight out of the Probate Act. The person in need is the disabled person. They must be over the age of 18 to fall into the disabled person. If they're below the age of 18, then we have what's commonly referred to as minors guardianship. People below the age of 18, children. And again, our bullet points here in the black squares are statutory because of mental deterioration. Again, was it a stroke? Was it Alzheimer's disease? Or physical incapacity? Is, fill in the name, John Doe capable, fully able, or not to manage his or her person? Because of mental illness or developmental disability, is Jane Doe not fully capable of managing her person, her health care, or her estate, her assets? So the term person means health care. The term estate means assets. Because of gambling, idleness, debauchery, excessive use of intoxicants or drugs, so she or he wastes their estate to expose themselves or their family to want or suffering. You can see the old-time English language there. Is an individual diagnosed with fetal alcohol syndrome or fetal alcohol effects? Obviously, this is a scenario in which the individuals reached the age of 18 and they were diagnosed much younger. Again, below the age of 18, minor guardianships. Above the age of 18, adult guardianships. Next slide. So as I mentioned, the role of medical professionals in a guardianship case is critical. It is outcome determinative. It is imperative. The determination of whether the person is disabled, to what extent a disability has any practical impact upon the decision-making capacity, particularly the need for guardianship, and the assessment of the least restricted options for care and treatment should be made by qualified medical or other specialists. Again, you need to be a licensed physician to write this report. The physicians may rely on an occupational therapist or a physical therapist to give them information, but the opinion comes from a certified doctor, a certified doctor that, as I said, must put in print his or her opinion. What's the diagnosis? What's the prognosis? Can an individual make their decisions regarding management of assets, management of healthcare? Are they partially capable? Are they totally incapable? And again, this is a determination by the court or a jury, judge and jury, based upon a medical report. You're going to have a jury trial or a contested trial. The doctor is likely to be coming into the courtroom. Some courtrooms allow for Zoom testimony, much like we're doing tonight. But the medical opinion is critical to a determination as to whether an individual has capacity to make their own decisions. So let's take our hypothetical. Bob, a widowed retiree, 70 years old, lives on a large condo in Lakeshore Drive. Bob goes to church every Sunday as well as the senior center twice a week to play chess. He has only one child, Mary, who lives in Florida and visits on major holidays. Lately, Bob is becoming increasingly forgetful, confused, disoriented, and is hospitalized after slipping on a patch of ice, injuring his hip. While in the hospital, he's diagnosed with dementia. He refuses to move out of his condo, so he hires a caregiver to help him with daily activities, such as laundry, cooking, and making sure he was properly dressed, since he occasionally forgot to change his clothes. Bob is incredibly lonely following his injury and his diagnosis. He finds consolation and companionship with his young caregiver, Stacy. Stacy could be coming in from an agency, doesn't matter. Stacy might be placed by the hospital, doesn't matter. Stacy's a very attractive divorcee with a child. Stacy dotes on Bob from the start. In addition to her duties as a caregiver, she starts to pay his bills, accompany to church, and go shopping with him. It wasn't long until their new relationship took a romantic turn. Stacy and her son immediately moved into Bob's opulent Lakeshore Drive condo. Shortly thereafter, the two made travel plans. Stacy suggested Bob buy her a new car, particularly a luxury SUV, so they would travel and have enough room for all of their things. Stacy took Bob to the Lexus dealership where he bought a 2023 Lexus SUV. He wrote a check for half of it and financed the rest. Stacy suggested that he put her name on the title as well, since she would be driving the SUV during their trip. Bob agreed quite readily. Now that Stacy and her son were living with him, she suggested Bob get rid of any other quote unquote nosy caregivers and housekeepers because she would be the only caregiver he would need. Stacy then suggested to Bob that he add her name to his bank accounts so they could do their grocery shopping and take care of household things. She also suggested they meet with his stockbroker to make sure she could use those funds to take care of him. In addition, Stacy says he should call his lawyer to discuss revising his will so she would be taken care of. Bob says, Stacy, anything for you, and gave her the numbers to call and make the appointments. So what's going on here? Stacy's now adding her name to every account and wants a new will done. Stacy's name's on all these accounts. Those assets are in joint tenancy. Bob dies, Stacy gets it. Stacy wants to withdraw the money. Once she's a joint tenant, she's able to withdraw. Meanwhile, Bob's daughter, Mary, is beginning to get concerned. It's increasingly difficult to reach her father. Don't forget, Mary lives in Florida. He's always been a very cautious decision maker. And when Mary learned that he moved a woman into his home after only 6 weeks, she became very worried. Mary, however, was afraid to say anything because she knew how lonely her father was, and she felt maybe this was what he really wanted. While in town for Thanksgiving, Mary went to an attorney to see what she can do. She was named her father's POA, power of attorney, agent a few years back. Her lawyer discovers Bob has not only redrafted his will, replacing Stacy with replacing Mary with Stacy as a beneficiary and naming Stacy his new power of attorney agent. So this is real trouble now. This daughter is stumbled into and basically moving too slowly in a scenario where Stacy's moved in, got her name on all the accounts, got her name on her a new will, and dad is cognitively impaired. So what's the first thing Stacy needs to do? Excuse me. First thing Mary, the daughter, needs to do. She needs to get a physician's report. In Cook County, it's called a CCP 211. It's a pre-printed form. Virtually every county in certainly the northern half of the state uses a very, very similar, if not identical form, in which the physician's report, as I've mentioned earlier in our presentation, requires a diagnosis that Bob, the respondent, that's the terminology in the courtroom, suffers from one of the following that renders him or her partially or totally incapable of making personal and or financial decisions. As you saw earlier in the slide with the black boxes, mental deterioration, physical incapacity, mental illness, or a developmental disability. Now, Stacy wants to get, Mary, the daughter, wants to get into court as fast as possible and ask the court to appoint a doctor, to appoint a temporary guardian. Temporary guardians have limited powers. They can act for 60 days, but an emergency like this financial exploitation, my law firm has filed hundreds, if not thousands, of these temporary guardianships on an emergency basis to get right in and prevent Bob's assets from being stolen because Stacy's really got her eye on that money. Next slide. So as we file the petition for temporary guardianship, we also file a petition for plenary. You can see that plenary, which means a full guardianship simultaneously. Temporary guardianship requires we say why we need a temporary guardian. Well, in this instance, judge, the caregivers now put her name on all of the assets of Bob, who's been diagnosed with Alzheimer's disease. We have a medical report here, capable of making his own decisions regarding the management of his assets, management of his health care, and we need to protect the immediate welfare of Bob, the alleged disabled person, regarding his medical decision-making and his estate. Don't forget, if Stacy is the power of attorney for health care, she can reject treatment to prolong or cure. Bob's not going to get cured from Alzheimer's, although there's new medication that's helpful. But she could deny Bob surgery if he fell down and broke his neck, for example, and he survived, and they say surgery will save him. Power of attorney agent financially exploiting him could say, nope, thumbs down, no surgery. So critically important that we get in there on an emergency basis. After the filing of a temporary guardianship petition, the court's going to appoint a guardian ad litem. Guardian ad litem is a lawyer the judge selects to act as the eyes and ears of the court, to go out and interview Bob if capable, to interview Stacy, to interview Mary, and to investigate the circumstances at the condo, at the hospital, wherever those interviews occur. And that guardian ad litem goes out because the court can't go out. The judge can't go on, put on his or her robe or take it off and go out to the condo and go out to the hospital. So she sends a lawyer. He sends a judge, female or male, sends a lawyer in their stead to investigate and report back both orally and in writing, requiring a written report. Next slide. So that's the role of the guardian ad litem. Again, typically the eyes and ears of the court, and go out on an exigent basis, emergency. I've been appointed in hundreds of these cases. I get a call on a Monday and I'm asked to be back in court Tuesday afternoon. Drop everything, Carrie, we have an emergency. You need to go to the hospital, find out what's going on. Talk to the doctors, talk to the nurses, talk to Bob, talk to Stacy, talk to Mary, and get back here tomorrow. I want to know how to do what I can do to protect this man if the doctor says he can't make decisions. Next slide. So again, a temporary guardianship has the powers and duties enumerated in the court order, very limited. Next slide. Plenary guardianship, we have to lay out the relationship and the interest of the petitioner, this instance, the daughter, to her father, basic information, the reason for the guardianship, time, date of birth, place of residence, et cetera, et cetera, et cetera. Any known children, perhaps a spouse, deceased if the spouse is, we need to disclose that to the court as well. Next slide. This is a continuation. We need to disclose the value of the estate, the value of the personal property, meaning the assets non-realty, the value of the realty, any income that might be generated from that realty, and who is the person seeking the appointment of the guardian. Next slide. So, guardian of the estate, management of assets, okay? Guardian of the estate, management of assets, carry out the disabled person's wishes if possible. This is a person who's going to manage Bob's assets. Why? Because we think Stacy's stealing them. Excuse me, next slide. Guardian of the person, management of medical, management of caregiving, management of where Bob's going to live. Can we get honest caregivers to come in and work in Bob's condo? Does Bob need a nursing home? What type of care does he need? Does he need 24/7 care? Does he need an RN in? Does he need a CNA? Does he need an LPN? What type of care? That would be the guardian of the person making a recommendation to the court, authorized by the judge to spend Bob's money on his care. Next slide. So the guardian needs to comply with the Probate Act, needs to comply with the order of court, and those are the requirements that the judge will impose upon the appointment. Next slide. Again, potential residential placement, and that may be, as I mentioned, a nursing home or something of that nature. Next slide. All right. So, ladies and gentlemen, thank you very much. Before we get to the questions, I want everybody to be aware. We at my law firm, the law firm of Peck Ritchie, have offices Chicago, Lake Forest, Northbrook, Oakbrook. We are the designated legal education partner of the Alzheimer's Association. So we teach these types of classes for the Alzheimer's Association. And the phone number, which is on the slide up there, call us at 312-201-0900 for a free initial consultation. That may occur over the phone, could occur by Zoom, and it could occur by a face-to-face meeting. So I want to thank you for joining us, and I'm going to turn the floor over to Mark, and we'll answer your questions. Thanks so much.
Yeah,
all right.
thank you so much. I just wanted to make a quick announcement that I'm just going to stop the recording so then we can get to the Q&A. Sorry about that, Chelsea. You can go ahead.
It's okay. Can everybody hear me okay?